In any event, the petitioners did make an effort in their letter dated 9th May 2025 addressed to the Registrar of Political Parties seeking information on her political party, her status, that is between the period 2020 to 2024. Regarding the constitutional challenge under Article 10 and Articles 10 and 72, 73, Sub-Article 2 of the Constitution, the fourth interested party avers that mere allegations without proof fall short of the constitutional standards. And her denials again are reproduced in this judgment. She has also cited Article 91, which outlines minimum requirements for political parties, and submitted, and this is important, that the meaning of being a member or holding a position in the party's governing body is that which is defined by law and not by perceived roles or titles. We will go straight to the determination on that issue. The question is whether the fourth interested party, having admitted that she served as director in charge of legal affairs within Jubilee political party, qualifies as having held office in the governing body of a political party within the meaning of Article 8.8, Sub-Article 8, Sub-Article 2A, Roman 2, and therefore whether she is disqualified from being appointed to the IEBC. We have already given the justification for constitutional disqualifications. In this case, the applicable provision is Article 8.8.2A, Roman 2, which we have reproduced in the preceding part of this judgment. We have relied on the case of Goganyo versus IEBC Selection Panel, a 2022 decision, on the burden of proof lying on the petitioners to establish that political activity or affiliation is of such a nature as to render the nominee ineligible under Article 8.8.2A, Roman 2 of the Constitution. In the absence of any credible record, assertions or constitutional disqualifications or impropriety would remain speculative and legally inadequate. But we proceed to answer that question substantively in the succeeding paragraphs. To do so, we must interpret the Constitution. And in interpreting the Constitution, this court is bound by the provisions of Article 259, which require the Constitution to be interpreted in a manner that promotes the purposes, values, and principles, that advances the rule of law and human rights and fundamental freedoms in the Bill of Rights, and permits the development of the law and contributes to good governance. We have reproduced that Article 259 and relied on cases including David Ndii and others versus Attorney General. You will read for yourself the parts that we have highlighted as being critical. We have also cited the case of Center for Rights, Education and Awareness, that is CRU, and 7 others versus Attorney General 2011, a decision by Musinga J, still on interpretation of the Constitution. In that case, several other cases or judicial pronouncements were cited with approval. Article 165 3D grants this court jurisdiction to hear and determine any question respecting interpretation of the Constitution, including determination of the question whether anything said to be done under the authority of the Constitution or any law is inconsistent with or in contravention of the Constitution. So we have set out the principles, and applying those principles and proceeding to interpret that Article 88, we have reproduced that article just for clarity and what the petitioners allege. And this is what we find. As correctly submitted by the fourth interested party, this court takes judicial notice that Article 88(2)(a) Roman 2 must be interpreted in light of other relevant constitutional and statutory provisions. Article 91, on the other hand, and Section 4 of the Political Parties Act require political parties to establish internal democratic structures and define their governing bodies in their respective constitutions, and this is underlined. We have reproduced Article 91 and also Section 4 of the Political Parties Act. Members of party governing bodies often play key roles in candidate nominations, coalition building, and election strategy. The appointment to IEBC would therefore, in our view, create an inherent conflict of interest, particularly when resolving disputes involving their former or affiliated parties. And we have reiterated that the IEBC is constitutionally mandated to conduct free, fair, credible, and impartial elections. Therefore, a person who is or recently was part of a political party's leadership, as defined in that Article 88, is presumed to have partisan loyalties or interests. Their presence on the commission, that is on IEBC, could compromise or appear to compromise the neutrality of IEBC decisions, especially in party-related disputes. Disqualification of political party governing body members under Article 88, the sub-article stated, is intended to protect IEBC's constitutional obligation to be independent, impartial, and credible. It promotes fairness, avoids conflict of interest, and sustains public confidence in the electoral system. For this court to determine whether Ms. Mary Karen Sorobit was a member of the political party's governing body, we must examine those provisions, and we have indeed examined them in detail. We have also relied on the case of Musalia Mudavadi versus Registrar of Political Parties. In that case, the court emphasized that the registrar's records are authoritative in determining party office bearers. In this case, there are allegations founded on title of the fourth interested party's perceived membership to the political party's governing body. However, there is no legal or structural backing to that allegation. Having examined those provisions that we have stated, and also reading the provisions of Article 233, which bear similarity with Article 88(2), in the former article, which concerns appointment of commissioners of the Public Service Commission, it is clarified under Article 233(3)(d) that any person who, under D, is or has at any time been the holder of an office in any political organization that sponsors or otherwise supports, or has at any time sponsored or otherwise supported a candidate for election as a member of parliament of a county assembly or of a county assembly. Unlike the above Article 233(3)(d), to be a member of a political party or holding an office in a political party, other than holding office or standing for election as a member of the governing body of a political party, would not be a disqualification from being appointed as IEBC commissioner. Article 882 is not as expansive as and restrictive as the similar sub-article 3D of Article 233. The drafters of the Constitution in this regard were deliberate in their choice of words in each of the respective articles, and therefore each article must be read and interpreted in its own context. The petitioners, in our view, have failed to demonstrate that the fourth interested party held office in the governing body of a political party as defined in law. And of course, we have looked at the Political Parties Act as well as Article 91. Those provisions must be read together. Her alleged role as Deputy Executive Director Legal, which was not proved following her clarification during her vetting by the National Assembly, appears to have been administrative or technical in nature and does not, without more, amount to holding office in a political party's governing body. We therefore find and hold that the petitioners have not demonstrated that the disqualification under Article 882A, Roman 2, applies to the fourth interested party. We have also considered the allegations of lack of integrity by the fourth interested party, and we are also mindful that technical competence, academic qualifications, and professional experience, in as much as they are important, but that integrity matters most. We have read Article 73(2)A of the Constitution, which provides for the guiding principles of leadership and integrity, including selection on the basis of personal integrity, competence, and suitability, among others. Particularly, integrity is not an ancillary attribute. It's the very linchpin of public trust and legitimacy. In that article, it expressly mandates that leadership be based on personal integrity, competence, and suitability, placing integrity first by design and deliberately as being a constitutional choice. This, in our view, underscores the primacy of integrity and reflects the constitutional vision of public service on a trust, not merely a profession. A person may therefore possess such exceptional qualifications and vast experience, but if their character is tainted by dishonesty, corruption, or ethical lapses, they cannot meet the constitutional threshold for public leadership. This is what the courts in Trusted Society of Human Rights Alliance and Attorney General spoke to. We scanned through this petition and we found that integrity is mentioned over 120 times. The question is, where is the evidence or any piece of it that suggests that Mary Karen Sorobit was a person of no integrity and therefore she failed the integrity test stipulated in Chapter 6 of the Constitution, or that she failed to meet the minimum qualifications provided for under Section 6 of the IEBC Act. We have again restated the position taken in Trusted Society of Human Rights Alliance as Attorney General and found that the petitioners have failed to discharge the burden of proof required to demonstrate that the fourth interested party is constitutionally disqualified from being nominated and appointed to the Independent Electoral and Boundaries Commission on account of lack of integrity or on any other ground so far. We move to the allegations against the fifth interested party, Hassan Nur Hassan. We have already discussed the allegations against him, the first one being his familial relations with the leader of minority in the National Assembly, minority party in the National Assembly, and also the allegations that his name was snuck into the expanded shortlist. So we'll now proceed to determine the alleged disqualification under Article 882A, Sub-Article 1 of the Constitution, which specifically and exclusively refers to persons who have stood for elections as members of Parliament or County Assembly, and not to those who contested for office of governor or other positions under Article 180 of the Constitution. We have interpreted those provisions applying the principles for constitutional interpretation. Allow me just to highlight, without going into much detail, you will read for yourselves. The operative disqualification is at Article 882A, Roman 1, which specifically refers to those who have stood for election as member of Parliament or of a county assembly. And we have answered the legal and constitutional question whether this clause implicitly brings in or includes gubernatorial candidates, or whether its meaning is confined only to those who vied for seats in the National Assembly, Senate, or County Assembly. As stated elsewhere in this judgment, and it's worth repeating here, Article 259 provides for how the Constitution should be interpreted, and in this regard, we have relied on several other decisions: Center for Rights, Education and Awareness in the matter of Interim Independent Electoral Commission, Jasbir Singh Rai and 3 others, Speaker of the Senate and another versus Attorney General, I will just highlight here that on the interpretation that promotes good governance and accountability, courts have held that interpretation of the Constitution must reinforce the values of transparency, accountability, and integrity under Article 10. And in the Speaker of the Senate and another versus Attorney General, the Supreme Court stated that constitutional interpretation should strengthen democratic institutions and good governance. It's also a settled principle of constitutional interpretation that where the language of the Constitution is plain, clear, and unambiguous, the duty of the court is to give effect to that language as written without straining its meaning or importing extraneous concepts. And we have progressed by relying on other decisions, and on interpretation concluded that where the Constitution speaks in plain terms, it must be interpreted according to its natural and ordinary meaning, and courts must resist the temptation to legislate from the bench by infusing provisions with meanings that are neither supported by the text nor required to fulfill its purpose, that is, the purpose of the Constitution. This is not to say that the Constitution shall be interpreted restrictively, but that courts must avoid giving an interpretation that leads to mutilating the Constitution and, in effect, rendering an unconstitutional decision when interpreting the Constitution. We have reaffirmed the principle of holistic interpretation of the Constitution, which requires that the Constitution be construed as a whole, with each chapter and article reinforcing and complementing the others. We have also relied on several decisions in this respect, and applying the above principles on constitutional interpretation and taking into account the petitioner's allegations and invitation to this court to interpret Article 882A clause Roman 1 to include governor, in our view, the principle of expressio unius est exclusio alterius, that is, the express mention of one thing excludes all others, is applicable in this case. If the drafters of this very robust, progressive, and always speaking constitution had the intention to include governors or other elective office holders such as president, deputy president, or deputy governor, they would have expressly done so in that article. We hold a further view that the Constitution is not to be interpreted in a manner that imputes intention where none is expressed or can be inferred in the context. In other words, constitutional disqualifications must not be expanded by inference to include persons who are not expressly mentioned unless it can be shown that such an inclusion is necessary to fulfill the objects of the provision, which is not the case in the present petition. Accordingly, the petitioner's invitation to this court to expand the scope of the constitutional disqualification clause to include other elective offices is not supported by law, neither is it supported by the Constitution, and to do otherwise would offend the principle of literal and purposive interpretation of the Constitution, as there is no ambiguity in that article or the language of the article as used. Additionally, there is no evidence placed before this court compelling us to read in that article anything else other than what is in situ. We have concluded that in light of the clear wording of Article 882A, subclause Roman 1, and having applied the principles of textual fidelity and non-interference with express constitutional design, this court finds that the phrase stood for election as a member of parliament or of a county assembly in that article does not include individuals who stood for election as governor. Moving on to the question of whether this interested party lacked integrity, we find no evidence placed before us suggesting even faintly that the fifth interested party was tainted with integrity issues. On whether he met all the other criteria in terms of competence among other criteria set out in Article 232, we have not been shown any evidence that excludes him from being considered for appointment as member of the IEBC. We reiterate our earlier finding that familial relations with political leaders is not a bar to seeking public positions which are competitive and where the seeker of the public office is found, if found to be competent and meeting all the other constitutional requirements for appointment to such office, he is given that opportunity to serve, noting in our introduction the Herculean task placed on such persons. I'll proceed and consider allegations against Fahima Arafat Abdallah, the seventh interested party. The petitioners impeached the nomination of Ms. Fahima Arafat Abdallah, the seventh interested party, on the ground that she is a public officer, state officer. They contend that she is therefore disqualified from being appointed as member of the IEBC, and that disqualification is the one articulated in Article 882B, similar to that of the second interested party. And the reason for that contention is that the seventh interested party was a member of the Lamu County Assembly Service Board. From the video recordings produced by the petitioners in relation to the vetting exercise by the National Assembly, it was revealed that the seventh interested party is a youth and received her early education in Shila, Lamu, She holds a Bachelor of Commerce degree from Kenyatta University and Master of Arts degree in Project Planning from the University of Nairobi. In addition to her academic qualifications, she has also undertaken various professional courses and is currently pursuing a Certified Public Accountant (CPA) qualification. She is a certified project management professional and holds a diploma in investment advice securities. Her public service career spans from being a ward administrator in 2014, a position she held until 2017, before transiting into being appointed as County Executive Committee member in various departments. Upon conclusion of her tenure as County Executive, she was appointed on a part-time basis to serve at the Lamu County Assembly Service Board. The issue is whether membership in the County Assembly Service Board constitutes holding a state office, or whether that board in itself is a state office within the meaning of Article 260 and any relevant statutory provisions as may be designated.